presumption of law are of two types. One is rebuttable presumption of law and another one is irrebuttable presumption of law. So we have to understand first what is rebuttable and what is irrebuttable. So rebuttable presumption is a kind of presumption where certain legal rules are there, okay, defining the amount of evidence which is required to support a particular allegation. Okay, for example, I have presuming that if a married woman within 7 years of his marriage has the dead body of that married woman has found in a very suspicious circumstances. There are blunt injuries and it is unnatural death. So according to the law, this much thing need to be proved. This much means how much thing need to be proved to establish that this is a like murder or any conspiracy. We can say there is a conspiracy, or after doing a conspiracy the woman would be murdered. So what we have to prove? First thing is the death would have caused in an unnatural manner. There would be burnt injuries. Time period would be 7 years from the marriage. Then the woman have been undergone any kind of cruelty regarding dowry or any other kind of things. So we can establish that, or the court shall presume that it is a kind of dowry death. There also it is being provided that by certain legal rules, by providing certain amount of evidence which is requisite to support a particular allegation, you can also support that or you can also rebut that. Understood? So how this can be rebutted? Okay, so the in-laws or the family members, they can show that the woman has a tendency to attempt for suicide. There are many kind of mental conditions जोथरे लोक माने कोन करନ୍ତି सुइसाइड करिया को ट्राई करନ୍ତି मे बी समाने प्रूफ करै देबे जे एटिके सिजोफ्रेनिक थिला सब बेले एमती मरिया को ट्राई करथिला एंड ता पई हमें डॉक्टर देखिएछु हमें डॉक्टर पाखु ताको लेकी जाइछु हमें ट्रीटमेंट करिछु ता पर भी सब बेले से अटेम्प्ट करूथिला प्रीवियस जदी भी किछि हिस्ट्री थिबा हिस्ट्री ऑफ अटेम्प्ट जोथरे कि वुमेन को बंचा हितबो ताको भी एज ए प्रूफ देखा जाय परिबो and a evidence take is the कथाटा को rebut करा जाय परिबो. So that is called rebuttable thing. एटा लॉ रे
मैम मैम रिबटेबल कथाटा म बुझी पने रिबटेबल इरेबटेबल मानेटा कोन
रिबट रो माने नॉर्मल इंग्लिश माने गो कोन डे टू डे लाइफ रे वर्ड यूज करूथिबो कि रिबट बैक करिबा you can challenge. Okay,
yes ma'am.
Okay, you can challenge certain thing or you can say that this is false or it is a claim or it is a proof that something is false by giving evidence. माने वो लीगल मीनिंग टा कुछ तमे किछटा जिंस को चैलेंज कर परिबो कि तमे एविडेंस दे कि किछटा जिंस को भूल प्रूफ करि परिबो. That is irrebuttable. Okay, irrebuttable कोन? Irrebuttable means तमे एविडेंस दबा पई कि you are not permitted. Once it is being written in the law that this presumption would be taken, and by law all the categories or characteristics of evidence is being satisfied, so it is the presumption of the court. No one in this world can change that. Understood?
माने मैम रिबटेबल ले डिस्प्रूव करी हबो आ इरिबटेबल ले आ डिस्प्रूव करी हबनी किछि
करी हबो नहीं बस हला काइंड ऑफ से एजेंस कोर्ट से प्रिजम्पशन नेबे प्रूफ डिस्प्रूव कथा भी हमें कहि परिबानी यू कैन चैलेंज दैट थिंग जेमते कि मु सेजन बुझोतली कि जदी दी जणा पुओ छिया सांग होई कि गोटे घरे रहउचंती एंड झीटी किसी सर्टन रिलीजियस जिनस क्यारी करछि जमते कि मंगलसूत्र हेगला सिंदूर हेगला तांकर बिहेवियर लागुच से माने परस्पर सहित गोटे इंटीमेट रिलेशनशिप अच्छंती आमे कोन प्रिज्यूम करिया
ସେମାନେ husband wife
they are married with each other and they are husband wife. This is the presumption of fact. Normal. but एमती ही husband wife हुआ तो एथरो presume करागला but can't it be changed? Is it
It can be changed.
yes is
They can
it
be
yes is it mandatorily be right that they are husband and wife? They can be brother and sister, they are residing with each other, or this can also be happen that the woman is the wife of another man, but both are them are staying together. Okay, or might be they are in a living relationship. So anything can be a possible circumstance. Okay, so when in case of presumption of fact and presumption of law, if any kind of presumption are being taken, that can be challenged. Okay, in rebuttable case, that presumption can be challenged. So if you are challenging a presumption, you have to put adequate evidence before the court. Getting my point? And if
yes
your
ma'am
evidence satisfies the court shall change its presumption. Clear? Okay, so this
yes
is
ma'am
rebuttable presumption. But on the other hand, irrebuttable presumption could not be challenged. Okay, so there are very less provisions in there under Indian evidence law which talks about irrebuttable presumption under BS. So section 118 you can see, 116 you can see of BSA, that is provided for the legitimacy of a child. Okay, so if a child is born from the mother and the husband of the mother within continuance of a valid marriage, number one, or after like separation of the husband wife within 280 days, then the child would be or the child shall be presumed to be a legitimate child. This is the principle. Okay, according to the rules, you cannot challenge. Okay,
ମ୍ୟାମ୍ ବୁଝା ଆସିଲାନି
से कौची जदि गोटे चाइल्ड रो बर्थ हिच ओके चाइल्ड को सेते बेले लेजिटिमेट बोली धरा जिवो जेतेले चाइल्ड रो मदर आउ से माने चाइल्ड रो मदर रे जे हस्बैंड फादर वर्ड सेठी यूज करा जाय नाही हला चाइल्ड रो मदर आउ चाइल्ड रो मदर रो हस्बैंड गोटे वैलिड लीगल मैरिज रे थिबे ओके दिस इज द फर्स्ट कंडीशन बुझे होची जिंस
yes ma'am
ए आउ
yes
बिकर
ma'am
मैरिज हैला मैरिज रो 2 वर्ष पर तांगर गोटे पिलाटी जन्म होला देन द चाइल्ड इज अ लेजिटिमेट चाइल्ड बी कहि परिबनी कि ये पिलाटा मोर नुह बुझे होची जिंस सेकंड
yes
जदि फादर और मदर कर बा मदर और मदर हस्बैंड रो डिवोर्स हिच आउ से छुआटा डिवोर्स हबार 280 दिन भितर जन्म होइछ क्लियर ताहेले भी से छुआ को से फादर लेजिटिमेट चाइल्ड बोली किना एक्सेप्ट करा जे बुझेला
yes ma'am
ओके ए दिटा केसेस रे को भी हस्बैंड एया क्लेम कर परिबे नाही जे चाइल्ड लेजिटिमेट चाइल्ड नोहे ओके दिस इज द जनरल रूल एक्सेप्शन कोन एक्सेप्शन होची जदी मदर जे हस्बैंड थिबो से कोर्ट को सैटिस्फाई करै दबो जे एट द टाइम ऑफ और जेतले चाइल्ड कंसीव हेतला सेतेले तार चाइल्ड रो मदर सहित कोनोसी रिलेशनशिप नथिला माने फिजिकल रिलेशनशिप नथिला ता हेले याको रिबर्ट करा जाय पारियो क्लियर
ମାନେ ମ୍ୟାମ୍ irrebuttable ଜିନିଷଟା ବି ରିବଟେବଲ ହେଇପାରିବ
रिपोर्ट करे जे पारिबो बट देयर इज very less chance.
Yes, ma'am.
Very less chance. So this is one provision. Basic provision nahi irrebuttable presumption na. ଆଉ ଗୋଟେ ଅଛି section 35. section 35 କହୁଛି will ବିଷୟରେ ଆଉ ଗୋଟେ probate ବିଷୟରେ ହେଲା। will କଣ ତମ ମାନେ ବେସିକାଲି ଜାଣିଥିବ, ମୁସଲିମ ଲରେ ପଢିଛ, ଇଏ ହିନ୍ଦୁ ଲରେ ବି will ବିଷୟରେ ତମେ ଟିକେ ଟିକେ ପଢିଛ। will ହଉଛି ଯେତେବେଳେ ଗୋଟେ ପର୍ସନ ତାର ନିଜର ସବୁ ଯାକ ପ୍ରପର୍ଟିକୁ କାହାକୁ ଡେଡିକେଟ କରିଦିଏ, ଯେ ମୋର ଡେଥ୍ ପରେ ଏଇ ଲୋକକୁ ମୋର ସବୁ ଯାକ ପ୍ରପର୍ଟି ମିଳିବ। ତ ସିଏ ତାର ନିଜର କୌଣସି ରିଲେଟିଭ ହଉ, ଫ୍ୟାମିଲି ମେମ୍ବର ହଉ, ଅନନୋନ୍ ହଉ, ଷ୍ଟ୍ରେଞ୍ଜର ହଉ, ହିନ୍ଦୁ ଲରେ ସେମିତି କିଛି ଲିମିଟେସନ ନାହିଁ, ଯେତେ ଏମିତି ମୁସଲିମ ଲରେ ଲିମିଟେସନ ଅଛି, ତମେ କେବଳ 1/3 ପ୍ରପର୍ଟି will ରେ ଦେଇପାରିବ, ବାକି ତମେ ଦେଇପାରିବନି। ହିନ୍ଦୁ ଲରେ ସେମିତି କିଛି ନାହିଁ, ଜଣେ ତାର ଏଣ୍ଟାୟାର ପ୍ରପର୍ଟିକୁ ବି will କରିଦେଇ ପାରିବ। ତ will ର एक କଥା ତମେ ଜାଣିଛ, will ରେ ପାର୍ଟିସ୍ ଥାନ୍ତି, ଯିଏ ହଉଛି ପ୍ରପର୍ଟି ଦିଏ ତାକୁ କହନ୍ତି, ଆମେ କଣ କହନ୍ତି, ଟେଷ୍ଟାଟର। ଯାହାକୁ ପ୍ରପର୍ଟି ଦିଆ ହୁଏ ତାକୁ କହନ୍ତି ଲିଗେଟି, ଆଉ ଯୋଉ ପ୍ରପର୍ଟିଟା will ରେ ଡେଡିକେଟ କରାଯାଏ ବା ଟ୍ରାନ୍ସଫର କରାଯାଏ ତାକୁ କହନ୍ତି ଲିଗେସି। ବର୍ତ୍ତମାନ will ଟା ସେତେ ଦିନ ଯାକେ ଏକ୍ଜିକ୍ୟୁଟ ହେଇପାରିବନି ଯେତେ ଦିନ ଯାକେ ସେ ଲୋକର ଡେଥ୍ ନ ହେଇଛି। ଏତିକି ବେସିକ କନସେପ୍ଟ ତ ତମର ମନେ ଥିବ। ତାପରେ
Yes,
କେମିତି
ma'am.
will ର ଏକ୍ଜିକ୍ୟୁସନ କେମିତି ହୁଏ। ବର୍ତ୍ତମାନ ଗୋଟେ ଲୋକଟାର ଡେଥ୍ ହେଇଗଲା, ଏ ବୋଲି ଗୋଟେ ଲୋକ ଥିଲା, ସିଏ ତାର ସବୁ ଜାଗା ପ୍ରପର୍ଟିକୁ ମୋ ନାଁରେ will କରିଦେଇଛି, ଏ ର ଏବେ ଡେଥ୍ ହେଇଗଲା। ମୁଁ ସେ will କୁ ନେଇକି ଯିବି କୋଉଠିକି, ସିଭିଲ କୋର୍ଟକୁ। ସିଭିଲ କୋର୍ଟକୁ ନେଇକିନା ଦେବି ଯେ ଦେଖନ୍ତୁ ଏମିତି ଗୋଟେ ଆପ୍ଲିକେସନ ଦିଆହବ ତା ସହିତ କି ଏ ବୋଲି ଯୋଉ ଲୋକ ସିଏ ତାଙ୍କର ସବୁ ଜାଗା ପ୍ରପର୍ଟି ମୋ ନାଁରେ will କରିଦେଇଛନ୍ତି। ବର୍ତ୍ତମାନ ସେ ଏ ର ଯଦି କିଏ ଲିଗାଲ ଏୟାର ଥିବେ, ତାର କେହି ରିଲେଟିଭ ଥିବେ, କି ଏମିତି କେହି ଲୋକ ଏକ୍ଜିଷ୍ଟ କରୁଥିବେ ଯେ ଲିଗାଲି ଏଠୁ ପ୍ରପର୍ଟି ପାଇବା କଥା ଥ୍ରୁ ସକ୍ସେସନ, କୋର୍ଟ ସମସ୍ତଙ୍କୁ ନୋଟିସ ଦେଇକି ଡାକିବ। ମୁଁ ଯୋଉ ସିଚୁଏସନ କହୁଛି ସେ ଜାଗାରେ ମୁଁ ଏ ର କେହି ରିଲେଟିଭ ନୁହଁ, ଏ ର ରିଲେଟିଭ ହେଲେ ବି କୋର୍ଟ ସେଇଆ କରିବେ। ସବୁ ଯାକ ଲିଗାଲ ଏୟାର, ସବୁ ଯାକ ପର୍ସନ ଯୋଉମାନେ ଏଠୁ ବା ସେଇ ଲୋକଠୁ ଟେଷ୍ଟାଟର ଠୁ ଲିଗାଲି ପ୍ରପର୍ଟି ସକ୍ସିଡ କରିବା କଥା, କୋର୍ଟ ସମସ୍ତଙ୍କୁ ଡାକିବ, ସମସ୍ତଙ୍କୁ ପଚାରିବ। ଇଭେନ ଯଦି କାହାର ଅବଜେକ୍ସନ ବି ଅଛି, ଏମିତି ହେଇପାରେ ବହୁତ ଲୋକ କଣ କରନ୍ତି, ଯୋଉମାନେ ଡେଥ୍ ବେଡରେ ପଡିଥାନ୍ତି ତାଙ୍କର ହାତ ଟିପ ନେଇଯାଆନ୍ତି। ଓକେ, ଏମିତି ବି ବହୁତ ଜିନିଷ ଫ୍ରଡ ଜିନିଷ ହୁଏ। ତ କୋର୍ଟ ତାଙ୍କୁ କହିବ ଯେ ଏମିତିଆ ଗୋଟେ ଆପ୍ଲିକେସନ ଆସିଛି, ତ ଯଦି କାହାର କୋଉ ବି ଲିଗାଲ ଏୟାର କିଛି ଅବଜେକ୍ସନ ଅଛି ସେମାନେ ଆସି କୋର୍ଟରେ କୁହନ୍ତୁ। ଫର ଏକ୍ସାମ୍ପଲ ଅବଜେକ୍ସନ ସଷ୍ଟେନ ହେଲାନି କି କାହାର କିଛି ଅବଜେକ୍ସନ ନାହିଁ, ତ କଣ ହବ, କୋର୍ଟ ଗୋଟେ ଅର୍ଡର ପାସ୍ କରିବେ, ଦ୍ୟାଟ ଇଜ କଲ୍ଡ ପ୍ରୋବେଟ ଅର୍ଡର। ଓକେ, ସେ ପ୍ରୋବେଟ ଅର୍ଡର କୁ ଏକ୍ଜିକ୍ୟୁଟ କରା ହେଇକି will ର ଯୋଉ ପ୍ରପର୍ଟି ଜଣଙ୍କ ନାଁରୁ ଆଉ ଜଣଙ୍କ ନାଁକୁ ଟ୍ରାନ୍ସଫର କରାଯାଇ ପାରିବ। ତେଣୁ ଖାଲି ସେ will ର କାଗଜଟା ଦେଖିଲେ ସେଟା ରେଜିଷ୍ଟର୍ଡ will ହଉ କି ନନ୍ ରେଜିଷ୍ଟର୍ଡ will ହଉ, କିଛି ତା ଦେହରେ ଲାଭ ନାହିଁ ଅନଲେସ୍ ଆଣ୍ଡ ଅନଟିଲ୍ ତମେ ପ୍ରୋବେଟ ଅର୍ଡର ନ ଆଣିଛ। ସୋ 35 ରେ ସେମିତି କହିଛି, ସେକ୍ସନ 35 ରେ ଯଦି ଗୋଟେ will ପାଇକି ପ୍ରୋବେଟ ଅର୍ଡର ଇସ୍ୟୁ ହେଇଛି, then it will be presumed that the will is a valid will. ବିକଜ ପ୍ରୋବେଟ ଅର୍ଡର ଇସ୍ୟୁ କରିବା ଆଗରୁ କୋର୍ଟ ବହୁତ ସାରା ଜିନିଷକୁ ଏକ୍ସାମାଇନ କରିକିନା ସେ ଅର୍ଡରଟା ପାସ୍ କରନ୍ତି। ତ ଏମିତି ପବନରେ ଅର୍ଡର ପାସ୍ ହେଇଯାଏ। ତେଣୁ ଯଦି ଜଣେ ପ୍ରୋବେଟ ଅର୍ଡର ଦେଖଉଛି ଆଣିକିନା ଏକ୍ସିକ୍ୟୁଟ କରିବା ପାଇଁ କି, ଦେନ୍ କୋର୍ଟ କଣ ପ୍ରିଜ୍ୟୁମ କରିବେ ଯେ ଦିସ୍ ଦ will is a valid will. That is also an irrebuttable presumption. ଆଉ କିଛି କୋର୍ଟ ଶୁଣିବେ, ତମେ ଆଉ ପ୍ରୋବେଟ ପାଖରେ ଆଣିକି କହିବନି ଯେ ନାଇଁ ପ୍ରୋବେଟ ଅର୍ଡରଟା ଭୁଲ ଅର୍ଡର, ଏଟା ଫ୍ରଡଫୁଲି ଦିଆହେଇଛି, ଗିଫ୍ଟଟା ଫ୍ରଡଫୁଲି ଏକ୍ସିକ୍ୟୁଟ କରାହେଇଛି, ଏସବୁ ଜିନିଷ ମନାଯିବ ନାହିଁ। ହେଲା, ତା ଦେହରେ ବି ଏକ୍ସେପସନ ଅଛି। Irrebuttable presumption, never think that irrebuttable presumption cannot be challenged. There are situations, provision you can challenge, but very less, very less. Okay. ସେମିତି ପ୍ରୋବେଟ ଅର୍ଡର କୁ ଚ୍ୟାଲେଞ୍ଜ କରାଯାଇ ପାରିବ ଯୋଉଠି ଗ୍ରସ୍ ନେଗ୍ଲିଜେନ୍ସ ସରି ଗ୍ରସ୍ ଫ୍ରଡ ହେଇଥିବ ବୋଲି ତମେ କୋର୍ଟକୁ ସାଟିସ୍ଫାଏ କରିଦଉଛ। ବୁଝାଉଛି ଜିନିଷ, ଯଦି କୋର୍ଟ ସାଟିସ୍ଫାଏ ହଉଛନ୍ତି ଯଦି ଫ୍ରଡ ଫୁଲି ଏ ଜିନିଷଟା କରାହେଇଛି, ତାହେଲେ ମେ ବି ତାକୁ ରିବଟ କରାଯାଇ ପାରେ। ତ ତାର ଚ୍ୟାଲେଞ୍ଜ କରିବାର ପରସେଣ୍ଟେଜ ବହୁତ କମ ଥାଏ। ଏଠି ଯେମିତି ସାଲ ପ୍ରିଜ୍ୟୁମ ହେଇଗଲା କି ମେ ପ୍ରିଜ୍ୟୁମ ହେଇଗଲା, you can challenge that, it is a kind of statutory right. Okay, but in case of irrebuttable, it is not a statutory right to challenge. It can only be challenged if the reason for which you want to challenge that is a satisfactory reason or that reason could satisfy the court, then only you are allowed. Clear? जदि फादर रा सॉरी मदर रे जे हस्बैंड थिबो से प्रूव कर दबो जे चाइल्ड कन्सीव हैला बेले मोर मदर पाखरे कोनोसी एक्सेस नथिला बा हमर फिजिकल रिलेशनशिप नथिला रीजन कोन ना मु 6 मास टोटल इंडिया रे नथिली तो ए चाइल्ड मोर हबो केमती देन कोर्ट अलाउ करि पारंते कि हां ठीक अछि डीएनए टेस्ट कर हैला कथा बुझी होछि जिंस
यस मैम
Yes, ma'am.
ओके लेख टिके तापरे पुणी नेक्स्ट
मैम ये जो अमरजीत सडा वाला केस रे भी सिया हेतला ना कि से डॉली इन कैपेक्स हमें कहले कि 7 ईयर रा तळे जे भी एमती काम करथियो त ताको हमें डॉली इन कैपेक्स कहे कि जुवेनाइल होम रे पठावा बट ता केस रे या देखाइला कि
7
तारा
इयर्स तळ
मैच्योरिटी एनफ
7 इयर सुन तार दीटा कैटेगरी अछि 0 रु 7 गोटे कैटेगरी अछि हैला
7 to
7
12
ରୁ
कोटे
12 गोटे कैटेगरी अछि ए जो 7
Yes,
जो
ma'am.
कैटेगरी टा सेटा टिके प्रॉब्लमेटिक कैटेगरी हैला 0 रु 7 भी नुए 7 इयर रु जार एज कम हेतियो हैला तो हां
Yes, ma'am.
सेटा को से
हम
कैटेगरी
से केस रे या देखाइला ना कि
मैच्योरिटी
से
एनफ
एते
थिला
मैच्योरिटी एनफ थिला कि भाबिया ପାଇଁ कि तार कन्क्लूजन को अछि
तादरे
हम
बहुत
कहले एटा
बढ़िया बढ़िया
हबो सेटा
हां कहले
एटा तार एग्जांपल हबो
इरिपटेबल
हां
नहीं नहीं सेटा हबनी काहे कि ना डोली इनकैपेक्स डोली कैपेक्स एगुडा सब एविडेंशियरी रूल नहे एटा सब्सटेंटिव रूल्स हैला एठी प्रिजम्पशन तमे केवल ड्रॉ करि परिबो अकॉर्डिंग टू द रूल्स ऑफ एविडेंस लॉ बा एबे जोटा हमर अछि भारतीय साक्ष्य अधिनियम बुझेला
बट ता माने भी तो से आइथिला ना कि गोटे सेति माने सेते छुआटा इनकैपेबल ऑफ डूइंग सर्टेन थिंग तो आमे या प्रिज्यूम करथरो कि एती वर्ष छुआर जदि तळे थिबो ताले आमे प्रिज्यूम करछि से पिला एते मैच्योर नाही कि गोटे क्राइम कमिट करि
नहीं
परिबो
तमे सेठी मे बी प्रिज्यूम वर्ड यूज करि पारो हैला सेठी को भी जगह रे तमे जदि लैंग्वेज पढिबो प्रिज्यूम वर्ड यूज करा जाय नाही सेठी क्लियरली लिखा है नो चाइल्ड who has under the age of 7 years is not liable for anything he has done. ओके हेडी कथा किछि आसीबो नै से
Yes, ma'am.
इंटेंशन नॉलेज मोटिव कामे किछि देखिबा नै एज केते 7 वर्ष रु कम सरला डन तापरे आ गोटे कैटेगरी देला 7 रु 12 सेटा प्रिजम्पशन कथा लिखा है कहला 7 रु 12 भितरे जो चाइल्ड फॉल करथिबे तांकर कोन करा जिवो ना मैच्योरिटी लेवल चेक करा हो हैला मैच्योरिटी लेवल तमे केमती चेक करिवो सेटा तो किछि गोटे सब्जेक्टिव जो ऑब्जेक्टिव जिंस नुहे सब्जेक्टिव जिंस ओके ताकू चेक करिया पे कि कोन करा जिवो ताकू किछिटा बेसिक क्वेश्चन पचरा हबो नंबर 1 अच्छा गोटे पिला को तार बहुत केस ला भी अछि आईपीएस रे मोर हटात के मन गोटे हीरा लाल करी गोटे केस अछि आ गोटे साउथ रे गोटे केस थिला आई मोइना कहि गोटे केस थिला से आई मोइना जो केस ता सेटा बहुत ही पुराना केस और सेटा को बहुत एक्सेप्ट करा जाय से केस रे कोन हितला से तार गोटे माने छोट पिला थिबो ता बाहागर कर देते ता हस्बैंड तो रात रे सब दिन पिटु थिबो गोटे दिन से कोन करबो साहस करे ता हस्बैंड को छुरी बुसी की जाय के गोटे जगह रे लुचि जी ओके तो से केस रे भी ताकू कोर्ट लायबल हेल्ड करते जा तक एज थिबो 8 वर्ष तार लायबल हेल्ड करे रीजन कोर्ट या देबे कि से कोन करची सीए सीधा हस्बैंड को छुरी बुसिला तपे जे लुचि गला से जो लुचिला ता माने ता माइंड रे गोटे इंप्रेशन आसला मु जहा कली सेटा गोटे भूल जिंस क्राइम ऑफेंस व्हाटएवर बट दिस इज अ रॉन्ग थिंग एंड सेठी काहे प्रिजम्पशन कथा आसीबनी सेठी कोनसी जिंस हम प्रिजम्पशन मु तुमको कोन बुझेली प्रिजम्पशन मींस गोटे फैक्ट एक्जिस्ट करूची तमे सेही फैक्ट रु आ गोटे फैक्ट को अज्यूम करछ बा इन्फर करूछ जे एटा जते एठी एमती अछि मे बी सेटा सेमती हेई पारे बट से जगह रे दैट इज लाइक रनिंग अंडर रूल्स ना सेठी प्रिजम्पशन को कथा रे आसुची मो कथा बुझी होउची रूल्स दे
हाँ
देला
मैम
कि
बुझिला
मैच्योरिटी लेवल जदि एनफ थिबो ताल तमे पनिशमेंट दबो नहले पनिशमेंट दबोनी छाड़ी दिया जिवो हैला तो सेठी तो फैक्ट रु जणा पड़ी जाउची ना मैच्योरिटी लेवल अछि कि नाही हैला तमे गोटे माने तुम तो लॉ स्टूडेंट प्रुडेंट मैन भी नुहे तुम गोटे लॉ स्टूडेंट हिसाब रे भाब दीटा चोरी छोट पिला चोरी कर दी जन जाकर एज 8 वर्ष जड़े कौन कर जनक घर को साइड घर को जाइए गोटे टेबुल उपर गोटे डायमंड थुआ होता पिला को जना नहीं से डायमंड कि कौन ताकू किसी जना नहीं से चिक चिक देखा से नहीं गले आणिक तार टॉय बॉक्स रे रखीदेला लगे मुझे गोटे टॉय मुझे खेली तो टॉय बॉक्स रे रखी आउ जड़े कौन कला से डायमंड टाकू नहीं ट्राए कला बिक्री करने अच्छा तमें को ये दीटा जाक सिनारियो रे काहा को पनिशमेंट दिया जिवो काहा को दिया जीवन
सेकेंड वाला केस बिकॉज से जानी छि कि यार मूल्य अछि एंड याको सोल्व करी हम
बस से हला कथा तो तमे फैक्ट रु बा सर्कमस्टेंस रु जानी दउछ जे एक्चुअली होउछ को तो सेठी इन्फरेंस रो कथा किछि नाही एठी एबे डिफरेंशिएट कर परछ कि प्रिजम्पशन कोन आ रूल ऑफ लॉ कोन हला
यस मैम
सेइत पई तो एबे गोटे बहुत बड़ मेजर इशू इंडिया रे देखा देलानी ता ऊपर लॉज माने बनेया भी ये करछंती वर्तमान माने पुआ झियंग भितरे जेतु सोशल मीडिया हलानी बहुत सारा जिंस डेटिंग ऐप को माने दीटा जेंडर परस्पर को एक्सेस करिया बहुत इजी जो टाइम रे पिला मानकर प्यूबर्टी आसे तो बहुत भूल जिंस लोक करत कारण हम इंडिया रे सेक्स एजुकेशन को एज ए एजुकेशन प्रोवाइड करा जाए ना वर्तमान टाइम रे होउची कोन माने पुआ भी माइनर झिया भी माइनर से माने परस्पर सहित कन्सेंसुअल सेक्स करछन किंतु बीएनएस को देख आईपीसी को देख लिखा है जे 18 इयर्स तळर जदि गोटे झिया कंसेंट दोउची दैट इज नो कंसेंट क्लियरली लिखा है हैला तो वर्तमान केस होचे या ताले जेटी तो किछि एज पुअर एज कथा किछि लिखा है रेप ऑफेंस रे खाली लिखा है झियर एज 18 रु कम हेले दैट इज रेप किछि जगह कोन होउची जेतु एजुकेशन लैक ऑफ एजुकेशन किछि झियो तादरु प्रेग्नेंट भी होउचंदी तो तांको घरे जणा पडुची घरे जानला पर तळे से पुआ कथा से माने घरे जानिया पउचंदी झियर फैमिली पुआ नारे सीधा रेप केस कर भाबो झियो वयस भी 15 कि 16 पुआ वयस भी 15 16 माने पुआ भी जो एक्टा करूची से भी जाननी जे एडा गोटे क्राइम हबो लैक ऑफ लीगल एजुकेशन लैक ऑफ सेक्स एजुकेशन तो वर्तमान how like the justice system would punish a minor boy who has no idea that whatever he has done that is an offense because से तो जानछि से झियो सहित कंसेंट नै कि से जिंसटा करछि ना बुझि होछि
यस
तो
मैम
ता ऊपर भी गोटे एबे नुआ रिफॉर्मेशन आनिबार टाइम आसिलानी से जिंसटा भी होउछि माने कथाबार्ता चलछि से लॉ भी चेंज कारण किछि फैमिली कौन करछंदी इगोइस्टिक है कि ना रिवेंजफुल है कि ना से छोटे छोटे पुंगा नारे भी केस करूछन ओके सो दिस इज अ वेरी लाइक प्रॉब्लमेटिक थिंग कारण आमे विक्टिम रा एज तो दोउचे बट अक्यूज रा एज विषय रे किछि मेंशन करा है नाही बट स्टिल जाय भेले इट इज एन ऑफेंस टेक्निकली देखिया गेले तो ऑफेंस ना सो तापरे पिलाटा जो पुआ
यस
पिलाटा
मैम
अछि हां ताकू केते सारा साइकोलॉजिकल ट्रॉमा हैंडल करे पड़िबो So, apart from that, please come to the chapter. So, understand what is
ସେତେବେଳେ ଦେଖିଲା ବେଳକୁ ଆଉ ଗୋଟେ ବି ଆସିବ ignorancia juris non excusat
ignorancia facit non excusat. Ignorancia juris excusat. Sorry, उल्टा कहली हाँ. Sorry. हाँ, you are right. हाँ. Ignorancia facit excusat. हाँ, juris non excusat. हाँ, से सीए गोटे प्रिंसिपल आछी. इवन 18 वर्ष तळर झियर विक्टिम रो जदी एज होची से गोटे प्रिंसिपल आछी. ओके. एंड झियो को भी बाध्य करा होची कि तू कहबु जे आमे कंसेंट देइनु कि मु कंसेंट देइनु इवन से कहिले बे मु कंसेंट देइछ तादर को फरक पड़ी ना सेजरो किछ फरक पड़िबार ही नै सो एमती सब जिंस धीरे धीरे हो जेटा गोटे बहुत मेजर सोसाइटल इशू एबे छोट पिलांग भितर सो थिंक ता ऊपर भी कथाबार्ता चलची मैरिटल रेप को ने कि एबे चलीची डिस्कशन whether it is criminalized or not तो तम माने कौन भाबुत आई डोंट नो बट मु तो कहिबी दिस मस्ट नॉट बी क्रिमिनलाइज्ड हेले बहुत ही जिंस प्रॉब्लमेटिक जिंस आसीबो माने नॉर्मली पुआ माने बहुत बेसी हैरेस हेबे एमती तो क्रुएल्टी डावरी एसबू केस रे पर्यंत हारास होउचंदी एटा आसिले आउरी बेसी हारासमेंट तांको हैंडल करया पड़े कारण यदि केसेस हेले किछि भी एविडेंस आदरु मिलिबो अदर एविडेंस मिलिबनी ओ केमती तमे को बेसिस रे जजमेंट दबो इमोशन बेसिस रे तो जजमेंट दे परिबनी आउ नॉर्मली झिया माने इमोशनल बीइंग झिया माने कांदंती एक्सप्रेस करंती पुआ माने एक्सप्रेस करंतनी हम सोसाइटी रे एमती तांको बढ़ा हिची कि बॉयज डोंट क्राई सो बर्तमान जे कांदीबो ता को कोन इमोशनल है कि ता फेवर डिसीजन दबो दैट इज नॉट आल्सो पॉसिबल तमे मैरिटल रेप को क्रिमिनलाइज करिया कथा नुहा एनीवे I mean, let's move to the thing. So I hope you are clear that what is the difference
Yes, ma'am.
between a rule and a presumption. Okay. So let's write the next thing. What is rebuttable presumption and what is irrebuttable presumption? Okay. So here we can give a very good example that a man is presumed innocent until he is proven guilty. So unless and until by putting evidence, you are not able to prove someone guilty, so man is presumed to be innocent. So this is the provision of rebuttable presumption. There are also a number of sections are there under BSA. We will discuss it later. So now just remember what is rebuttable presumption. Then comes irrebuttable or conclusive presumption. So these presumptions are certain legal rules which are not overcome by any evidence that the fact is otherwise. So if once every characteristics of the presumption is being matched, so nobody would overcome those facts otherwise. So there are exceptions I have already told, but till now please remember what is the basic difference between rebuttable and irrebuttable. In rebuttable we can challenge, we can by giving certain evidence we can try to overcome, but in irrebuttable case of this cannot be overcome. Okay. And it is also called as conclusive presumption. Okay, write down. Clear? So now this is the basics of presumption. Whatever we have discussed, the kinds, the types, rebuttable, irrebuttable. So now we have to discuss what is the presumption or what is the position of presumption under BSA or under the law of evidence. So under the law of evidence, there are three types of presumptions. One is may presume, then shall presume, then conclusive proof. Okay, clear?
Yes, ma'am.
1 second. My devices have hanged, I guess. No, it is not. So, the first presumption is may presume. So, we can call it is presumption of fact, it is natural presumption, it is kind of permissive presumption. So, it has a lot of name. Okay, presumption of fact, natural presumption, permissive presumption, etc., etc. Okay, so write down may presume. Now, first make the heading that presumption under BSA. And it is there under section 2 and subsection. Guys, please tell me what is the subsection of may presume? My Bare Act is not with me, that's why I could not find it.
I'm 2 class H.
Yes, thank you, thank you. Okay, 2H. So 2H talks about what is may presume or what is the definition of may presume. 1 second, please. Let me bring my Bare Act. It will be difficult to teach. Okay, 2H. So here it is provided that, so what is may presume? So whenever it is provided by the BSA, the court may presume a fact. It may either regard such fact is proved unless and until it is disproved or may call for proof of it. So basically it is a kind of presumption of fact. From the definition we are going to know it is a presumption of fact first thing, and if court has presumed certain thing or presumed a fact, that means it may be proved or the fact may be proved unless and until it has been disproved by providing any kind of proof or evidence. So already I have told what is may presume. Okay. So basically the presumption of fact or may presume that leaves to the discretion of the court to make presumptions according to the circumstances of the case. Okay, so it is purely discretionary, and such presumptions are not based on the law, but it is based on logic. In evidence, BSA, also there are many more rules are also there where you can find it is written may presume. In this case, court may presume this presumption of fact. If someone having stolen property is there, the court may presume the person is a theft. If both like a man and a woman staying like husband and wife, the court may presume they might have married. So in case of may presume, it depends upon the discretion of the court. And it is basically based on logic. Like more than rules, it is based on logic. And the other names of may presume, one is may presume. The other synonyms are presumption of fact. Okay, you can say permissive presumption. Or natural presumption. So is it clear? बुझेला?
Yes, ma'am.
Write down. Okay, and this particular thing, that this presumption relies upon the discretion of the court. This is held in the case of Bedpal versus Sakuntala. And write down the courts are to the circumstances of each case. Okay, next, such presumptions are based on logic more than law. Right, so this is our may presume or presumption of fact. Basically, we can see.
ଆପଣଙ୍କ ସ୍କ୍ରିନ୍ ଟା ଦିଶୁନି।
Yes, ma'am, off ହେଇଗଲା।
तो नेट तो ठीक अच्छी। तब मैं टिके रिफ्रेश करियो तमरा। Actually, this one. Okay now, एबे दिसला?
Yes, ma'am.
Yes, ma'am.
तो मो साइड रे प्रॉब्लम था। ठीक अछि। So, next, the next presumption is Sal presumption. Okay, and another one. This is also rebuttable presumption of fact. That also remember. Here it is written presumption of fact. I am writing here rebuttable presumption of fact. Remember. Then come Sal presumption. Okay. So the definition of Sal presumption is there under section L. Section 2, subsection L. And the other names of Sal presumption are rebuttable presumption of law, artificial presumption, etc. and it is a kind of mandatory presumption also. So no discretion is there before the court, or the courts are not permitted to have some discretion. So this presumption basically leaves no discretion or option with the court to make the presumption or not. The court is bound to take the fact as proved until evidence is given to disprove it. Like the dowry death, the presumption for dowry death. So it is there under section 118 BS. So in such circumstances, a woman's body is being a woman's body is being found. Okay. So then you can have the presumption that it might be dowry death. So here the court has no discretion. The court has to accept. That is a mandatory provision. So basically the definition of shall presume says that, so whenever it is directed by BSA to the court shall presume a fact, it shall regard such fact as proved unless and until it is disproved. So the same definition what is provided for may presume, here is also the same definition, but remember the difference between may presume and shall presume, here the provision is mandatory. The court has to take the presumption. There is no option. Right. Okay. Write down. To make okay. And here there are two case laws which we have to discuss. Those are important. So the first one is public prosecutor versus Thomas. But it is an Indian case law. Don't think that from foreign. Public prosecutor versus Thomas. 1959 Madras High Court. This is the case of Madras High Court. So here the court has held that, so shall presume means that the court is bound to take the fact. So whatever we have already discussed, that things are being discussed in this case. So here it is held that, so it means the court has to bound to take the fact as proved until and unless some other evidences are being adduced to disprove it, and the party who are interested in the subject matter of the case in disproving it must produce such evidence if they are able to do. Okay. So basically the crux of this case law is that it is mandatory. Okay. This presumption is mandatory. The court is bound to take. But lastly, if the parties who are interested to disprove the particular presumption, they are allowed to give evidence to disprove it. If they are able to do so, the presumption shall be avoided. The court shall not take those presumption. If those parties are not able to disprove the particular presumption, then it shall be full and final. Got it? So please write down. ମୋ screen visible ଅଛି?
ନାଇଁ ମ୍ୟାମ୍,
ନାଇଁ ମ୍ୟାମ୍।
ଏବେ ହିଁ ଅଫ୍ ହେଲା,
ହୁଁ।
ଏବେ ଆସିଲା ମ୍ୟାମ୍।
ଆଚ୍ଛା, ଟିକେ ନେଟୱାର୍କ ଇସ୍ୟୁଜ ରହୁଛି। Okay, so this is a case for Sal prism. Then the last presumption, that is conclusive proof, and it is called as irrebuttable presumption of law. So here the presumption is final. Okay, so no evidence can be adduced to contradict the presumption through a document or evidence which is a conclusive proof. So basically the courts are not allowed to accept or to take evidence to disprove a conclusive proof, but there are exceptions which I have already discussed. But till now, please remember what are the differences between three presumptions. In case of conclusive proof, the proof is like the presumption is final and no evidence can be adduced. Okay. And here also the court has no discretion. The court has to go with the rules and the laws or at the provisions which are there under the rules related to evidence. Okay, and this is it. And there is also a case law that is Sombanti versus State of Punjab. So in this case, Supreme Court held that so the conclusive proof gives a finality to the establishment of existence of a fact. Okay, so that's why the rules are final, full and final. No discretion is allowed and no evidence is being adduced to prove or to disprove the certain presumption. Okay, that is also subject to certain, like I am always saying that to make you remember that there are exceptions, but normally as a general rule it is not challenged. It cannot be challenged. Clear? Last one, conclusive proof. This is under section 2, subsection by clause B. But what is the definition of conclusive proof is there? We have to look at it. So conclusive proof means one fact is declared by BSA to be conclusive proof. So basically it depends upon the rules of BSA, not the judgment, not the examination of the court. Conclusive proof of another. The court shall on proof of one fact regard the other as proof and shall not allow evidence to be given for the purpose of disproving it. So already it is been written. The court shall not allow evidence to give or for the purpose of disproving it. Okay. So it can be called as conclusive proof or irrebuttable presumption of law. Okay. It is a kind of final presumption because no rebuttable or no rebuttal is being accepted, so it is final presumption. And secondly, no evidence can be adduced to contradict the presumption through a document or evidence. Okay, and the case is Sombanti versus State of Punjab. gives finality to the establishment of the existence of a fact. Okay. So the chapter 1 of evidence BSA Bharatiya Sakshi Adhiniyam is over. Okay. So is there any doubt regarding today's session? Please let me know. And notes I am sending you by tonight. Okay. There are small case law regarding edits need to be done. Then it is final and I will send it. So till now the chapter 1 is over. And in the next 30-40 minutes we will end the CPC portion, which are the rest of the question. So till now is it fine? Okay. No doubts? Am I audible?
No doubt, ma'am.
Okay. Okay, fine. So I am just closing this slide and opening another slide. So don't leave. The class is not over.